Good afternoon, ladies and gentlemen. Welcome to yet again another session of the stakeholder engagement process on draft civil aviation regulations. This last session for this morning, we will be considering the draft civil aviation certification, licensing, and registration of aerodromes. And like we said earlier on, this is one of the three regulations that was hived out of the Aerodromes Regulation 2013. And these regulations are aimed at providing guidance on the certification, licensing, and registration of aerodromes and heliports, as in support of the first two regulations presented by my colleague, John Akinywa. So I'll be presenting these regulations and I'll present the matrix of amendments. It is important to recall that these regulations were first issued in 2018, and this is an amendment of the regulations. So there are a few amendments that have gone with the regulations. The first one is under interpretation. We have correctly defined aeronautical information publication to align with the other technical documentation in the authority. The term authorized person has been deleted from the regulations. Dangerous goods, data accuracy, data integrity, assurance levels have also been included. Instrument runway has been removed, as well as lighting system reliability. So those are the adjustments that have gone into Regulation 2, interpretation of the draft civil aviation certification, licensing, and registration of aerodromes. Regulation 5 subregulation 1 has been reworded for clarity, where we are now saying a person shall not operate an aerodrome in Kenya unless the aerodrome is certified, licensed, or registered in accordance with these regulations. So we've reworded that for clarity to indicate that no person shall operate an aerodrome that does not fall in those three categories, or is not certified, licensed, or registered. Regulation 10, the marginal note has been reworded to read breach of conditions. Previously, it read breach of conditions of certificate and non-compliance certificate requirement. It has just been reworded to read breach of conditions. Regulation 11 sub 2 has been deleted. It's redundant. However, the provision relating to what that subregulation intended to cover can be found at Regulation 13 subregulation 5. Okay, that is to do with certificate issued under these regulations not being transferable. That has been addressed under Regulation 13 subregulation 5. We have also reworded Regulation 17 subregulation 5 to match what the Act provides for in terms of tribunal. So we're saying a holder of a certificate who is aggrieved by the suspension of a certificate may appeal against suspension to the tribunal within 30 days of the suspension. So we're just referring those appeals to the tribunal as provided for in the Civil Aviation Act, and that permeates through 6, 7, and 8. We have also redrafted Regulation 18, surrender of certificate, for clarity. So the regulation has been redrafted for clarity, and you can go through the regulations indicated. Regulation 26 has also been redrafted. A breach of any conditions to which a license is issued shall be subject to enforcement by the authority. Just as we have also rewarded regulation, there's a regulation we've rewarded there in, sorry, I'll just go back to it. The marginal note in Regulation 10. Similarly, the marginal note in Regulation 26 will also be rewarded to indicate breach of conditions of a license, so that this reflects to a license. Regulation 10 relates to a certificate. In subregulation 2, we've also replaced the word shall with may, that the authority may impose operating restrictions or sanctions, to mean that this is optional. The previous regulation read that the authority shall, as if it was compelled to impose operating restriction. Regulation 32, surrender of a license, has been also rewarded for clarity. If you look at the text, it differs with the original text in the 2018 regulation. and is just aimed at bringing on board some clarity on the provisions surrounding the surrender of a license. We have also included Part 4 in these regulations. Previously, the certification licensing and registration regulations did not explicitly address the issues of heliports. So we have provided for Part 4, which addresses licensing of heliports. The entire part is a new part that has been introduced to address licensing of heliports. Regulation 61 on aerodrome certification continued oversight has also been provided for. This is provided for to give guidance on continued compliance and surveillance, continued compliance by regulated entities or aerodrome operators, and surveillance by the authority. Regulation 62.62 enforcement has been rewarded, and the rewarding is aimed at ensuring that we have clarity on how we address penalties under these regulations. So if you read regulation 62, we have rewarded that to provide clarity in the administration of penalties in these regulations. And Part 7 is also included to provide guidance on heliport manual. Remember, we've just included the issue of heliports, and therefore Part 7 also comes in to provide guidance on heliport manuals. Regulation 76 is a new provision which protects persons from liability, and this is a provision that is going to permeate itself throughout our regulation sets. It just deals with protection or from personal liability. Then we go to Regulation 77 on offenses and penalties. This is a regulation that breaks down the offenses in this set of regulations and provides for penalties for each offense creating regulation. So this regulation, as read together with the 5th schedule, would make clear on how the penalties in these regulations, what attracts penalties in the regulation and by how much penalty. Then there's the 4th schedule, which is introduced pursuant to the new regulation 36, which addresses heliports. So this schedule, the 4th schedule, is on the particulars to be included in an heliport manual. And then the 5th schedule is also a new schedule which breaks down the penalties as provided for in Regulation 76. So those are the brief changes that have gone into these regulations. So I will also go through a series of comments that we have received. We have received some comments here from one Sylvia Waiganjo. He's an advocate with the Gerivia Advocates, and the comments are as follows. The arrangement of regulations under Part 2, number 19, which reads charges at certified aerodromes, at certificated aerodromes, to read charges at certified aerodromes. That we'll take on board. This is a typo or an editorial we can actually take on board and adjust. Under Section 2, bold the words being defined, and that's an editorial. She's just pointing us to regulation drafting that probably we missed in the process of production of this draft. Then there is a comment there that the word accident, as defined in the Act, is there any need to repeat the definition under Section 2 of these regulations? So we'll be taking this up with our legal team to advise us on the best drafting approaches so that we can determine whether we need to define the word accident again when it is defined in the Act under which these regulations are made. Then she's also raised a concern in terms of definitions of the words aerodrome, state safety program, that the definitions we have provided in these regulations differ from that which is provided for in the Civil Aviation Act. We will be reviewing that and ensuring that the appropriate definition is provided. Under Regulation 26, she's raising concern that consider having non-conformance with the licensing requirements instead of breach conformance to license requirements. So she's actually pointing us to the marginal note that I referred to in my matrix, and we will be considering the guidance provided by Council on that one. Regulation 27, Sub-Regulation 4 is a grammatical error which we have been pointed to, and we will be taking action to address that grammatical error. Regulation 42, Sub-Regulation 1A, we are being told to replace article "an" before the word heliport. So it's a typo, is a grammatic issue. It should be a heliport. That also follows through in Regulation 42, Sub 4 and 5. In Regulation 45, Sub-Regulation 46, Sub-Regulation 5, we are being asked to allow an appeal. It says it allows an appeal to the Cabinet Secretary, yet the Act provides for an appeal to the tribunal. So again, we will go through these with our counsel and look at the provisions of Regulation 46, Sub-Regulation 5, and read that together with Section 69 of our Act, and come up with the appropriate text that does not create confusion or duplication of any manner. Again, there's a typo in Sub-Regulation 6 of Regulation 46, which says the suspension should be varied in terms of the drafting. So Regulation 47, 1 is we are being told it aimed to omit the word "at any time," since going by Section 2, a license cannot be surrendered without giving a 90-day notice to the authority, which means that a license can be surrendered, but only upon giving notice. So there is some administrative arrangement there that is not coming out clear, that you can only surrender a license when you give notice. It is not practical in the context of what the interventions that she has given us. Regulation 49, 2F, we are told to delete the word, the letter "a" after the word. And Regulation 57, A, we are being asked to separate the words regulation, and if Regulation 58 means, and Regulation 58, we need to do the numbering. 72, we are being told that the authority should not bear costs for acts or omission done negligently. This is where we're talking about protection from personal liability, but I think the advice we're getting is also to ensure that the authority does not bear costs for negligence or acts or omissions done negligently. And then in Regulation 73, she has pointed out to a typo. So those are the written remarks that were received in advance in respect of the certification, licensing, and registration of aerodromes regulations. I can see in the chat, Joseph Okumu has talked about Regulation 33 Sub-Regulation 3, which says the regulator may prescribe the maximum charge at which may be levied for use of the aerodrome. Are these charges not controlled by the parent ministry? So it's asking if the charges that may be levied are not controlled by the parent ministry. So that is under Regulation 33, which talks about charges at licensed aerodromes. I will invite my colleagues if any has an intervention to make on that regulations. However, the regulation that Mr. Okumu is talking about reads that a holder of a license shall prescribe charges for the use of the aerodrome or any facilities provided at the aerodrome for safety, security, efficiency, and regularity of air navigation. And Sub-Regulation 2 says, where required, by the authority, a holder of a license shall furnish particulars of the charges levied for the use of an aerodrome or the performance of services at the aerodrome. Then it says, not with subregulation 3, which is the contentious one, notwithstanding subregulation 1, the authority may, where necessary, prescribe the maximum charges which may be levied for the use of an aerodrome or performance of service at an aerodrome for a specified period. So that is the one that Bwana Okumu is referring to. And I think I'll allow my colleague David to make an intervention on that question.
Thank you, moderator, for the opportunity to respond to the question that has been asked by Mr. Joseph Okumu regarding to the interpretation of regulation number 33, subregulation 3, in terms of the authority being able to prescribe the maximum charges. I think the genesis of this provision, Mr. Okumu, if you may know, there was a precedent where the private aerodrome operators were levying charges that were higher than what was being charged specifically at major airports, and there were complaints that arose under this. However, as you rightfully say, that they are subject to the intervention of the parent ministry. That's correct, but it's also in order that we regulate the charges that a particular aerodrome operator is able to charge for the support of the sector, and to ensure that there are no exorbitant charges that are chargeable in terms of utilization of these facilities. If you may remember, there was a matter that had been arbitrated in a court of law and the direction given regarding to this. I think we can consult further on the same, but I think as drafted, we can have it so, and maybe have further consultation if you can submit additional proposals on how we can enhance it. But the intention of the provision is right for purposes of having control in terms of the charges that are charged by holders of lands, especially the holders of private aerodrome. And the bigger picture here is supporting the tourism sector in the country to have this mobility and movement within the country. Thank you. I return it back to the moderator. Harrison, I may think maybe, could you give him time maybe to respond?
Just continue.
You may need to maybe take the floor, Mature, to ask your father on, because the statement is clarification on charges. I don't know that you need on the same regulation 33.3, or you have a different issue on charges. Kindly, maybe through the moderator, if you could give him an opportunity to speak. Thank you.
Yes, I think as David has said, Mr. Mature, we have activated your participate button. That will allow you to speak and probably make us put your the clarification sought in context to allow for a better response. You're welcome. Please go ahead.
Thank you, Lawrence. Concerning that charges, and as clarified by David, if the regulation is meant for private aerodromes, then we urge case here to remove the ambiguity, because the law must be very clear that this kind of clause is regulating maybe private aerodrome operators. But if you leave it the way it is, then it means even public aerodromes are also supposed to be regulated under that clause. And you are aware that these are regulations. Regulations in terms of weight, they are lower compared to the acts of parliament. So, like, for example, the K Act of Parliament, Cap 395, it states clearly that our charges shall be approved by the minister or the CS holding that portfolio. So we cannot have two approvals where we get approval from the minister as well as from the regulator. I think that is my submission. Thank you.
Thank you, Mr. Machio. I think we have noted the concern that comes with the way that regulation is currently drafted. So what we can do is we will look at the text so that we can address the right context or the right type of aerodrome, so to speak, because the way the concern I've seen is with you being one of the operators of licensed aerodromes, the role of the regulator in terms of what you're saying. So we will look at the regulation so that we can reorientate the regulation to address the right context of the aerodromes under consideration. And further also note that the drafting also uses the word may, so it's not a must, but we appreciate your input. And in our review of the regulation based on your input, we will be considering your intervention. Okay. So any other questions or interventions? Yes, I can see Gad Kamau. Gad Kamau would like to speak, so we are going to activate your... Okay, Gad Kamau, you can take the floor at your convenience.
Mr. Chairman, can you hear me?
Yes, go ahead.
Thank you very much. On charges, it's a very sensitive issue right now because most of the aerodrome service providers, like KA is a monopoly. We don't have an option as operators to turn to in case we are dissatisfied with their services. It would be prudent for the regulator to step in, not only public aerodromes charges, even the ones that are run by county, to come up with a structure that will be charged to aircraft landing in those areas. Because, and I'll give you a good example, is the Mara, where those airstrips are charged more than even Wilson Airport. And the condition and the surfaces and the service that is offered is nowhere near Wilson. We need to be protected as operators from exploitation. And regulator, as you are also involved in seeing the growth of aviation in this country is uninterrupted, it's unhindered. You can step in when you feel that there is a certain service provider that is hindering the growth of the sector because of the exorbitant charges they are levying towards users or towards aviation stakeholders for the use of their facility. Once you license or certificate or register an airstrip, it would be prudent if you could come up with a charge rate or a charge tariff that the service provider, the operator of that aerodrome, will have to refer to when they are levying charges towards users of that facility. Thank you very much, Mr. Chairman.
And Mr. Machio, you can see the orientation of that regulation. So despite the concern that KA has on that regulation, from GAD's input, there is something we need to do, and I think we will just think of redrafting that regulation so that to take care of the concerns the operator have with regard to charges at some of these aerodromes that are not owned by KA, or KA, for example, and then we intervene to see if we can cushion our operators. I don't know if Mr. Machio, you'd like to go or to have a go at it also again. Mr. Machio, we can we have activated your participation. You can go ahead and have your right of response to that.
Thank you. I think the fears that Captain Kat Kamau is raising, to me, there is no issue there, because even us, before we levy the charges, we strictly follow the ICAO guidelines on user charges. So the charges are not done arbitrarily. We hold stakeholder sessions for them to have the buy-in before maybe escalating or increasing the charges and whatever. So it is on mutual agreement and through public participation, which is a constitutional threshold. And I don't know why Gad Kamau thinks that even the regulator cannot exploit him, because the regulator can also put charges which is going to leave you crying. So let's think around this issue, because it is not just a walk in the park. Once the law is made, it should be clear that it is regulating this and this. But as I've said, regulations are secondary to acts of parliament. So we cannot have another regulator or approval regime on top of what the act is telling us to do. That's my concern. Thank you, Chair.
Sorry, I think we had a small internet hitch there. Thank you very much, Machio. I think your sentiments are well taken. We appreciate. Like I promised, our moderation of the regulations after listening to your comments would take on board the concerns of KA and as well as the concerns that have been expressed by Captain Gad Kamau, and that should be able to address both sets of stakeholders in a bid to enhance aviation in this country. Any other questions so that we can be able to conclude this morning session of the stakeholder engagement? So I do not see any other questions. However, we would encourage you to us or to write to us any comments or any views that come to mind through the email kcars2021@kcaa.or.ke. We'll continue to receive comments and incorporate them in the final drafts of the regulations. And like we had promised, we'll also get back to you and deliberate the final drafts before we proceed on the publication process. So before we call this, before we wrap up this session, I'd allow the manager responsible for oversight of aerodromes, David Ondieki, to give his terminal remarks on the not only this set of regulations, but the regulations we have seen since morning, before I wrap it up and we take a break. So David.
Thank you so much, moderator, for the opportunity to respond and provide a feedback on the input that we have just received from participants. I'm so appreciative of the interactive nature of this session and most of the input that we have received, starting from the Aerodrome design and operations regulations to the heliports, and also this one on certification, licensing, and registration. The input given, including the communication that will be coming, will basically be taken into account, and more so the issues raised. We'll try to update the areas that have been pointed where we have the gaps so that we can be able to have an acceptable draft that can be able to be submitted for adoption so that it becomes easier for us to implement the same once enacted. So I sincerely appreciate the feedback that we have received, and even the issue of charges that has been raised. I think we are aware of the background that God has clarified. We are trying to ensure that it's resolved and such that no one is disadvantaged in terms of access, and ensuring that the sector is supported for purposes of growth. So the spirit here, if I may kindly respond to what my chair says, we are not trying to create a layer through the Kenya Civil Aviation in terms of granting approval to charges, but to bring arbitration in cases where we feel that there is due disadvantage that is being offered to the operators who fly to these particular aerodromes. So with that, I want to say thank you so much. I think there are additional questions on the window, or maybe from Felix Maina. He's asking if Mr. Macho, will this be the right forum to ask regarding the reduction of the airstrip size, or he was directing a question to Mr. Macho? But I think Mr. Maina, if I may say, if you have a challenge in terms of the operation of the airstrip, the dimensions and the characteristics associated in terms of your operation, you can submit a request to us at KCA. We'll be able to give an advice, and we realize that it requires a design issue, then we may refer the same to the aerodrome operator. For further guidance, that's Kenya Airports Authority to give you further guidance, but you may share the same if we require that particular input. Kindly send us an email, we'll be able to provide. Moderator, you may take the next one maybe. But it's more of a comment. I think it's more of a comment. With that, I think I say thank you so much, and I'll hand it back to the moderator.
Thank you very much, David. I think Daniel Moss, we've had your comment. I think you are in concurrence with what Mr. Macho has articulated, and we recognize that. So we will not dwell much on that. So, ladies and gentlemen, it has been a full morning where we have been able to review at least 4 sets of regulation, with 2 very heavy regulations. We've been able to look at the rules of the air regulations, which has minimal amendments, about an 8-page matrix of amendments. Aerodrome design and operation was fairly heavy, with over 80 pages of amendments matrix. The heliports one was equally heavy, with more than 100 pages of matrix, and the last one we've done had just about 9 pages of the matrix. So we've done those 4 regulations this morning. Together with the regulations that were presented from Monday, we are so far doing about 20 regulations, with about 10 to go and 1 to be repeated. So we are fairly on track. This session is coming to an end right on track after at around 1 o'clock, where we have managed to regain some of the time that's spent on the heavier regulations. Again, my colleague Dennis has posted a live link for the next session. Please take note of that link so that you're able to join us on the next session. The next session would start at exactly 2 o'clock, and it would go into another 4 sets of regulations: the draft aeronautical charts regulations 2021, the draft meteorological services for air navigation regulations 2021, the draft units of measurements to be used in air and ground operations Regulations 2021 and the draft Construction of Visual and Instrument Flight Procedures Regulations 2021. So that would take us between 2 o'clock and 5 o'clock this afternoon. However, I would encourage those of us who have been able to interact with these regulations to prepare your questions and interventions on time so that we are able to address them as we go along. Without further ado, let's take a break at this moment and reconvene at exactly 2 o'clock. Thank you.